And it's a big development at this end because this is what we've been waiting for. It's taken its time, but there is a reason for that. It's a 919-page report, but the most operative parts, largely observations towards the last 2 or 3 pages. Pooja Prasanna joins us with some of the critical observations made in the detailed copy. Yes, Pooja.
Anand, as you rightly mentioned, it's an exhaustive report. Some of the key observations that we did see in the latter part of that report is that the income tax evidence that have been put forth by the defense has not been taken into the right perspective by the trial court. That is Justice Michael D. Kanha. That is one of the key observations, and that's what we've been reporting, that the key factor that weighed in Jayalalitha's favor is the income tax evidence, be it in terms of the witnesses that the defense had put forth or the profit and loss statements that they had provided. Also, the wedding expenditure of Sudhakaran, one of the accused, as well as he's also the foster son of Jayalalithaa. The accusation was that Jayalalithaa had, at conservative estimates, spent a total of 3 crore rupees on his wedding. That too has been struck down, saying that the prosecution has failed to actually provide any concrete evidence to prove the same. And also the value of the construction that were carried out by various firms associated with Jayalalithaa and the other accused. In this particular order, it says that the estimate was not done in a proper manner, and also it has said that the evidences that were put forth by the defense has not been taken into the right perspective by the prosecution. These have been some of the key observations by Justice Kumaraswamy, clearly saying, as we have been reporting,
right,
that all the evidences that have been put forth were only were not taken into the right perspective. Anand?
Well, reading from page number 915, where it says, in an appeal from a conviction, it is for the appellate court, as for the first court, to be satisfied affirmatively that the prosecution case is substantially true and that the guilt of the appellants has been established beyond reasonable doubt. Now, it is not for the appellants to satisfy the appellate court. Now, they are also saying that it comes out and says the powers of the appellate court under this section are the same as that of the trial court. Just perusing down to page number 916, where it says, in this case, the trial court has ignored the income tax proceedings as minimum evidentiary value. The trial court has not appreciated the evidence in proper perspective. And then, though the trial court in its judgment mentioned that the accused availed loan, but it has not considered the same as income. Then it also says the trial court has erred in not considering loans as income. And they also say that even it has failed to examine the evidence relating to cost of construction at the relevant time and simply arrived at a conclusion of 20% of the cost to be reduced without reduction and is calculated on surmises and conjectures. They are also saying the trial court has assessed the marriage expenses at 3 crore rupees. There is no acceptable evidence to point out that A1 had spent about 3 crore rupees. A1 in this case is Jayalalithaa, accused 1. Now, in spite of it, the trial court has arrived at the figure of 3 crore as a modest and conservative estimation. Arriving at that amount towards marriage expenses and fixing liability to A1 alone is not proper. They also say most of the claims put forth by the accused have been rejected by the trial court. It is a contention of the learned counsel for the appellants that without treating the witnesses as hostile, the witnesses were recalled and cross-examined. The questions are put in such a manner that whether they are stated in the examination in chief is correct or the cross-examination is correct. By securing answer to this question and also by adopting this method, they cannot wipe out the answers elicited in cross-examination. Now, there is also another strong observation which has come in, which says, I'm just going to scroll down and now this is page number 918. In view of the above discussion, I pass the following. Criminal appeal number 835 by 2014, 836 bar 2014, 837 bar 2014 and 838 bar 2014 are allowed. Now, these are the 4 appeals that were put in by Jayalalithaa, Ilavarasi, Sudhakaran and Sasikala. Niranjan also joins us with the details. Niranjan, I'm sure you've also got a detailed copy of the judgment. It's an exhaustive 919-page report, but it's a severe indictment of the way the trial court has come across its judgment and based its judgment on. That is what has been quashed.
Right, Anand, while we stay on, the visuals and the first copy of the order that we're getting here, I'm just going to read out what the order says, and Times Now has an exclusive copy of what the Karnataka High Court has said in its final verdict this morning. I'm just going to read out the order in view of the above discussion. I pass the following, and this is what the High Court Judge, Judge Kumaraswamy said this morning. He said, criminal appeal numbers 835/2014, 836/2014 and are allowed. He says the judgment of conviction and sentence passed in special CC number 208 of 2004 dated 27th of September 2014 on the file of 36th Additional Cities Civil and Sessions Judge, Special Court for Trial of Criminal Cases against Jayalalithaa and others, Bengaluru, is hereby set aside. Appellants accused numbers 1 to 4 are acquitted of all the charges levelled against them. The bail bonds of A1 to A4 are discharged. The appeals in criminal appeal and the others are allowed in part. Back to you, Anand. This is the first copy of the order.